Hello, my name is Joey Senat. I teach at OSU School of Media and Strategic Communications. I teach media law and multimedia journalism and deal with a lot of open government stuff. Thank you for inviting me to come in and speak with you about the Open Meeting Act. And by the way, that is Meeting Act, not Meetings Act. I see a lot of lawmakers and journalists get it wrong, so it's actually singular meeting, not meetings. I also wanted to point out that I'm not trying to give you legal advice. This is intended solely for your education. I tried to help you understand some major points here. When I do this training for county officials, they set aside 3 hours for it. I promise I'm not going to talk for 3 hours or try to cram 3 hours into a few minutes. But the point here too is when you're in doubt, consult your legal counsel because I'm just trying to educate you and I can't represent you in a lawsuit. So we're talking about the Oklahoma Open Meeting Act, and here's where you can find it on our state statutes on OSCN. And let's talk about the purpose or the spirit of the Open Meeting Act. When we say the spirit of it, you're expected to meet that spirit, the spirit of the act. That's the legislative intent. When courts and the AG and public bodies are supposed to interpret it, they should go to first, what is the spirit of the act? What is the purpose of it? Is our decision in this circumstance fulfilling that goal? And so here we see that the purpose of the Open Meeting Act is to encourage and facilitate Oklahomans' understanding of the governmental processes and governmental problems. So informed citizenry. So that should be your goal at all times. So how to apply it? Let's go through some things, talk to you about how to apply this, and that starts with liberally in favor of the public. And that's because, as our state Supreme Court has pointed out, the statute was enacted for the public's benefit. So it's liberally in favor of the public. And I explain that as in baseball, the tie goes to the runner. So the tie here goes to the public. Meet so that your meetings are open. When in doubt, follow the open meeting policy is that you interpret it liberally in favor of the public's advantage. Don't give it a construction that will subvert the intent of the legislature. You're supposed to interpret it so that you'll actually bring about that legislative intent, that spirit, that purpose of the statute. And that is to facilitate Oklahomans' right to participate in our government and understand why government acts affecting their daily lives are taking place. It should be interpreted as a way to avoid creating loopholes. We do have at times interpretations by public bodies and attorneys that sort of create a loophole out of something that's not what's intended. So again, you're supposed to act within both the spirit and purpose of the Open Meeting Act, operate with such openness that the public is informed of your activities, and again, when in doubt, follow the Open Meeting Act policy of the state. I don't know how much you all rely on Robert's Rules of Order. I run into this frequently with public bodies, and there's some confusion about whether or not Robert's Rules of Order supersedes the Open Meeting Act. It does not. The purpose here is, the point here is that there are times when the Open Meeting Act is silent. It does not tell you how to run the meeting. Robert's Rules of Order does that. So when the Open Meeting Act is silent, follow the Robert's Rules of Order. But when they come into conflict, when the Robert's Rules of Order would either conflict with a requirement or a prohibition of the statute, then you follow the statute. So what we've had an AG opinion say is all meetings of public bodies must be open to the public. And what they mean by meeting is a meeting of the majority. So if you've got a quorum together to discuss public business, that meeting, that gathering of a majority must comply with the Open Meeting Act. So, Open Meeting Act doesn't always apply when there's a majority together. For example, You're allowed to go out, gather at parties, go out to dinner together, go to social events. The Open Meeting Act doesn't apply, but there are restrictions on that. For example, you cannot meet informally to quote, decide any action or take any vote on any matter. And the statute adds you cannot meet informally if you're going to discuss public business. So you can meet informally as long as you don't discuss public business. Now, I know public officials around the state who are very concerned about this. They want to make sure that not only do they not violate the law, but they don't give the appearance of violating the law. So they just will refuse to be in the same room with people on their public body, even at a social gathering. They don't want it to look bad. You're allowed to gather socially as long as you don't discuss public business. Now, this is from an AG opinion dealing with the Corporation Commission. And this was the idea of, there are 3 people on the commission. Can they meet with public bodies? Can they meet with private entities when they're not discussing something on which they, the Corporation Commission, will actually vote on, something they could take action on? And the opinion said the majority could meet together, meet with government agencies, meet with private entities, as long as they're discussing broad, general matters. It may be related to the business of your public body, but it's not something on which you could take action. So we've had instances of this even with school boards over the years, and this sort of lays out, yes, you can do it. You could, for example, speak with a legislative committee who was looking into the area upon which you deal with, but as long as you're just helping them understand the business of the Conservation Commission or your district, that's fine. You don't have to comply with the Open Meeting Act as long as you're not discussing something on which you could take action at some point. So if it's solely helping the legislature understand what you do, that would be fine. So it does apply, the same AG opinion said, when you're considering these discrete proposals or some specific matter that's within your jurisdiction, something that you could take action on. It also applies when a majority of you meet with experts to gain insight into a matter under your purview. So if the majority of you want to go meet with somebody out in your district and get some insight, if the majority are together, then you've got to somehow post a notice for that meeting, let the public know when and where it's going to be, and it's got to be open to the public. So this AG opinion this past spring sort of summed this up again, that if majority convenes, even it's solely just to get information and you're not going to take action, the Open Meeting Act still applies. If you're going to discuss specific actions that you may ultimately be voting upon, then the Open Meeting Act applies. So we've been talking about majority. What if a minority meets? Less than a quorum. And I understand you've got 5 members on each district. So if 2 of you want to get together, and this AG opinion from the spring said, minority of members of public body, you can get together to receive information and even to discuss the business of the public body. And that's not really new. We've known that for years. The statute says quorum, majority. So it's always been then that if you've got a 5-member board, 2 people on that board can get together and talk about the public body's business. That's okay under the statute. This opinion went on a step further and explained that one of you could host a series of these discussions with other members, either one-on-one or in groups smaller than a quorum, to present identical information relevant to your business. Okay, so in other words, this is about serial meetings, series of meetings. And again, you can do it one-on-one, you can do it in groups of smaller than a quorum, as long as you're being presented with identical information. This happened with a school board years ago. They wanted to meet with staff, excuse me, to discuss some issue and the staff wanted to present them with information, and so they met in less than a quorum, and they split the public body up into two groups. Each of one was less than a quorum, so they could have that meeting, that discussion. Now, you're entitled to do that as long as, the AG opinion pointed out, you're not trying to circumvent the Open Meeting Act. And I'll tell you too that that school board, even if it were doing that today, it would still take a lot of criticism. The purpose of the Open Meeting Act is to inform the public, and we have previous AG opinions that talk about, that includes the entire decision-making process. The Open Meeting Act applies to discussions. As one AG opinion said, simply giving the public access to a rubber stamp vote is useless. That's not the purpose of it. The public should get to know why you make a decision, the pros and cons that were considered. That's facilitating their understanding of governmental problems and processes. So even though the statute might say you can do this, or an AG opinion says you can do this, you might still take criticism for it because it doesn't look good. And what the AG opinion says you certainly may not do is if you have those meetings to engage in vote counting or some attempt to reach a consensus. That's likely going to be a violation. So it doesn't have to be a formal vote, but if you're trying to come together with some sort of, well, three of us will go along with this, that's vote counting. And that's also not a new idea. We've had an AG opinion from decades ago that said you could not have a series of meetings, serial meetings, to reach a consensus. And again, what that would mean is one member meeting with another member of the public body. Okay, well, that's two. That's less than a quorum of a 5-member board. Then one of those two goes and meets with a third member and say, okay, the two of us have decided how do we want to vote, and we want you to vote our way. Well, as soon as that third person's involved, that's a majority. And that's what an AG opinion years ago said you couldn't do. You couldn't reach a consensus of a quorum by meeting in groups smaller than a quorum. And that's, again, what the AG opinion from the spring said. You cannot, while you can have these meetings to get identical information in less than a quorum, you can't use that as a way to circumvent the statute by coming to some sort of consensus. So you might discuss by asking questions of your staff, for example, but you couldn't have a discussion among yourselves that's trying to reach a consensus on what to do. And that also means that you shouldn't be having these discussions by email or by text message. If you send out an email to a staff member, do not include majority or quorum of the rest of the public body. Same with a text message. The danger here is, and by the way, even if a staff member sends it to one person or sends to the entire public body, you don't want to be responding, reply all, because that starts a discussion. And if that discussion is reaching towards some sort of consensus on how are we going to vote, what are we going to do, that's going to be deemed a violation. So you're safer when you don't have some sort of reply all mechanism when you're not trying to talk to everyone else on the commission, whether it be by email or text message. And this brings up an issue in the Open Records Act. I just wanted to point out that when you do text messages, email, any other communication, and when it's on your private smartphone, your private email account, it's still going to be considered public if it was made, received in connection with these three things. So transaction of public business, expenditure of public funds, or administration of public property. Doesn't matter that it's on your privately owned cell phone. This was an AG opinion by Drew Edmondson. It was an issue that was coming up across the country. And it basically, the idea that it would only matter who owned the device, that would sort of negate the need for an Open Records Act, because the public could simply, public bodies, government officials, employees, could simply avoid the Open Records Act by simply doing everything on their private laptop or their smartphone. or for that matter, even buying a yellow notepad, that belongs to you. It's private and it's no longer public. Courts have all rejected that. AGs across the country have rejected that idea. So again, just to make sure you understand, if you are doing public business, and that is a broad definition under the Open Records Act, on your private phone, email account, text messages, whatever, then it's going to be public. And when someone makes a request for records related to whatever that topic is, you are going to be expected to do a search of your emails, your text messages, and so on, to make sure that you're complying with that request. Now, what it won't mean, transaction of public business, what it won't mean is if, for example, you are making plans for a social event. We have an AG opinion from years and years and years ago, before this one, back in '09, that talked about, well, when was it public? When would these emails be public at a government body, a government agency? Does that mean that every email on the government server is public? Andrew Edmondson said, only if it dealt with these three things. And he gave us an example. If you were making lunch plans with someone, then that would not be a public record. You also have the retention schedule for the state of Oklahoma, and I recommend you all meet with your legal counsel to go over how long you should be keeping certain documents and certain records if you need to have a search for them. A couple last points here about the Open Meeting Act. Lawsuits. We don't have an independent commission or public body in the state to which the public can go and say, I think this public body has violated, for this example, the Open Meeting Act. Can you, help decide if we think if the violation is correct or if the public body is correct? What we do have in this state is an opportunity for anyone who believes the Open Meeting Act was violated to be able to file a lawsuit asking a judge to declare that whatever action was taken in violation of the statute is actually invalid. Excuse me. By the way, that just simply going back and revoting doesn't solve the cure. Doesn't cure the violation. That's not a solution for you. That's going to help with the original violation. And that person who sues is not going to have to prove that he or she was injured by your violation. Going back to why this is, interpreted liberally in favor of the public, it's because it was enacted for the public's benefit. We actually had an appellate court decision in the state saying this, and the legislature then adopted that into the statute. Anyone who thinks there's a violation can file a lawsuit. They don't have to have been injured by the violation that they're claiming. So not only can they have your action declared invalid, but they're also entitled to reasonable attorney fees. Now, if the lawsuit's deemed frivolous by the court, then the public body would be entitled to reasonable attorney fees from the plaintiff. I have never seen that in this state. I don't recall it ever happening. More than likely, if that plaintiff wins, they're going to be winning attorney fees from you. And it's also possible for the person to recover court costs. That's up to the judge's discretion. It's also a misdemeanor in this state to violate the Open Meeting Act. The maximum punishment would be a $500 fine and 1 year in the county jail. Although it's not common, we have had public bodies charged and prosecuted in this state for violating the Open Meeting Act. So you ought to understand what's going to be expected and what's going to be required of the prosecutors. So as a penal statute, the Open Meeting Act is to be strictly construed. In other words, it says do this or don't do that. That's what you should do or not do. The prosecutor's not going to have to prove criminal intent because whatever the conduct was, it's made illegal by the statute. So either don't do it or do it. If you didn't do one of those as you were supposed to or not supposed to, then that would be a criminal violation. The prosecutor doesn't have to prove that there was some sort of injury by anyone, simply that you failed to comply with the Open Meeting Act. So again, why is all this important? As our AG opinion in the spring pointed out, transparency in government provides Oklahomans with the opportunity to observe their government, to understand how decisions are being made. Government belongs to the people in this state, and we can't make informed decisions about what government's doing in our name if we don't get to observe what government's doing, either through the Open Records Act or in this case through the Open Meeting Act. And again, when a majority of the public body is together, video conference or teleconferencing, and dealing with the transaction of public business, then you should be meeting in the open. That basic idea is the underpinning of the Open Meeting Act. And lastly here, I want to thank you all for everything you all do. Whether the rest of us realize it or not, we benefit from your expertise and your willingness to serve in these public bodies. I know it can be confusing. It's confusing for county commissioners that I deal with at times. They're not sure what to do. And I believe that most public officials in this state want to do the right thing. It's just knowing what the right thing to do can be a problem. It can be a little confusing. So I had at the beginning of this my email address. You're welcome to email me. I will try to help you understand it, send you statutes, AG opinions. The books I write about this are all attempting to draw together all those sources and sort of doing an analysis for you so you don't have to read the statute separately and then figure out what an AG opinion or a court decision is said on it. So I'm glad to try to help you. If you think you're going to be sued, you think you might be in a criminal violation, if you're in that kind of doubt, definitely talk to your legal counsel. And thank you again. I appreciate this opportunity.